And after this, Stephen, feel free to take it away. Thank you.
Thanks, Christine. Hi, everyone. Thanks for taking the time to join this webinar today. I hope that the information that we have to discuss is useful for you. For those that may have joined either the most recent immigration options after graduation in early April or have been to any of my sessions previously, this one will be a little bit different. Instead of an overview of the entire immigration system, we're going to focus on two particular areas, particularly as they relate to COVID-19 and the impact that that's having on the immigration situation in the United States right now. Specifically, we're going to talk about first OPT and STEM OPT. And then secondly, we're going to move on to discussing H-1B. We'll also talk about some updates on relevant legislation and executive orders that have either been released or have been discussed, and try and give you an indication of what is likely, what is not, and what, if anything, you can do right now to be prepared for what may come through from this administration. So first, just a quick overview here. I'm going to be using some terms that have a specific meaning that are used maybe a little bit more broadly in normal speech, but in the legal world, these are distinct terms that have different meanings. So non-immigrant visas, these are non-immigrant status is temporary, it requires sponsorship, and is tied to a specific employer and or a specific institution. Your F1 status is non-immigrant. And there's also limitations in terms of specific visas. H-1B visa holders can only work for the petitioning employer, for example. F1 students can only engage in studies with their specific university. They have requirements for what kind of course load they have to maintain and all of that. Immigrant visas, in contrast, are green cards, is kind of the colloquial term for that. These are permanent statuses. It's not employer specific. Once it's approved, you are free to work for whomever you'd like or not work at all. And it's essentially unlimited in scope, like a US citizen, with some exceptions. Voting among them, also still subject in extreme circumstances to deportation, unlike a US citizen. But for all intents and purposes, it's permanent and unlimited. Again, just as a quick summary, there are a large variety of different apologies, just getting rid of some background noise there for a minute. There are a large variety of different government agencies involved in the immigration realm. And different agencies, right now, particularly with COVID-19, release different information that has different impact. So USCIS has released a variety of different updates with COVID-19. They're primarily responsible for adjudicating benefits in the United States. Your H-1B petition will always go through USCIS, for example. CBP are the folks at the borders and points of entry. So you're going to have to go through them to seek entry into the United States using a visa stamp in your passport if that's required for you. ICE is primarily the enforcement arm. However, for students, ICE is very actively involved through what's called the Student and Exchange Visitor Program, or SEVP. That's where a lot of the guidance is released from that impacts OPT and the like. Department of State relates to visa stamps outside the US. So the closure of US consulates, the hold on issuing of visas in most circumstances right now, that's all the Department of State that is controlling that kind of process. Finally, the Department of Labor is involved in some employment-based visa applications, H-1Bs, for example, and green card applications through the labor certification process is where the Department of Labor comes in. Just provide this summary to all of you so that you understand that you can't necessarily just go to one source to understand all of the impacts from COVID-19 and what has been adjusted. ICE isn't going to give you everything, neither is USCIS, Department of State. So all of these areas and agencies have different responses, most of which are aligned and make sense together, but you can't find them all in one source or from one agency because they have different areas of responsibility. All right, let's jump into the first of the two major topics we're going to discuss today, F1 OPT and STEM OPT. So ordinarily, I leave this discussion, the meat of this discussion, to your ISSS office and team. And they provide OPT workshops and the like to provide you the details that you need to pursue OPT and to understand the process. Because of COVID-19 in particular and the economic situation that we're in right now as a result, there are a lot of additional complications. So I'm going to take some time to talk through some of these complications. There are some things that we know, some that we don't, but I'll try my best to give you kind of best practice as well as what you can do to try and protect yourself depending on your specific situation. So the basics, just to give us an outline of and a base standard for our understanding. Optional practical training, or OPT, everything I'm referring to here is post-graduation optional practical training. I will not talk about pre-completion OPT. That's fairly rarely used, but everything I'm discussing here is after graduation. So it's an F1 student authorized for 12 months of practical training at each educational level. We'll talk more about the full-time piece of that, what that means. The work that you're performing, and work does not necessarily mean paid work in this context, we'll talk more about that as well, but the work must relate to the major area of study. You must obtain an employment authorization document by applying with USCIS prior to entering into employment with your employer. And the timing for that is you can file up to 90 days prior to your program end date, your graduation, and make sure that you submit the documentations no later than 60 days after your program end date. So you've got about a 5-month window to submit that OPT application. For those that are in a STEM field, there's a link here. You should have been provided the presentation just at the beginning of this presentation, hour and a half, by Christine. But those in the STEM fields listed in the document there with the link at the bottom are eligible for an additional 2-year extension on top of that 1 year, so 3 years total. You can file that renewal 90 days in advance, and you must file it within 60 days of the recommendation made by your DSO, by the ISSS office. So when they give you that documentation of that recommendation, you want to make sure you file that within 60 days. You must file it in advance of the expiration of your EAD card. Okay, so just some basics here. Cross comparison, comparing and contrast OPT versus STEM OPT. So OPT on the right-hand side, initial 1-year period. This is an important point that we're going to spend a lot of time on, unemployment. 90 days of aggregate unemployment for that 1-year period. Self-employment is permitted, so you can have your own business. You can even perform contract work. You don't have to be an employee of a company. You can even do unpaid work as a volunteer or an unpaid intern, but you want to make sure that that work is compliant with relevant labor laws. There are a lot of restrictions around unpaid internships, for example. Your employer should be aware of those, but if you feel like there's a situation that you have where an employer is not complying with relevant labor laws, that could be an issue not only for the employer, but potentially for you as well. So you want to try and be aware of that, maybe ask a few questions of the employer once you start employment or just right before you start employment to clarify exactly the terms of your unpaid situation. For STEM OPT, in contrast, you get 3 years total based on the 2-year STEM extension. You're allowed up to 150 days of aggregate unemployment. So for STEM, what that means is you can have 150 days over the course of the 3-year total. So your 1 year of initial OPT and your 2 years of the STEM extension. So for example, if you're on OPT right now, but you're eligible for STEM OPT and you accrue over 90 days of unemployment, let's say you get 100 days of unemployment, you likely are still in the clear and okay. Now, there could be some complications, some additional questions by USCIS, but as long as you're STEM eligible and you apply for that STEM extension and receive that STEM extension, you then are still under the 150 days allowed you of aggregate unemployment. In addition, STEM employers has to be an employment relationship, also must be a paid position. Your employer has to be an E-Verify employer. They have to enroll in E-Verify. That relates to the I-9 process that you have to complete when you start employment with any US employer. But they have to have signed up for that program. You have to complete an I-983 training plan with your employer. You have to submit a copy of that completed training plan to your DSO before they are able to provide you with the recommendation necessary to apply for the renewal. And again, no self-employment. So if you were on OPT, standard OPT, and you have your own company, that's permissible for standard OPT. That is not permissible. You can't be a business owner and self-employ yourself and qualify for STEM OPT. Okay, those are kind of the basics. ISSS folks, let me know if there are any questions as we go. I'm going to jump into some of the advanced topics. These were questions that I understand the ISSS office has been fielding and have been asked by students of late, most particular to our current situation with COVID-19, furloughs, layoffs, and new policies, different policies from the federal government as it relates to OPT and unemployment. So first, what qualifies as work under standard OPT? First, all work, quote unquote, must be related to the program of study. That's really important. And you want to have documentation of that from whoever you're performing that work for. So if you're volunteering at an organization, you're going to need to get a letter confirming why that volunteer work is related to your program of study. Here's a list of potential permissible activities. Regular paid employment, even with multiple employers. So, if you work 5 hours with this employer, 10 hours with that employer, and 7 hours with this other employer, that gets you over 20 hours. Under normal circumstances, that's more than sufficient, and that's just fine. Second, you can have a situation where payment by multiple short-term employers. So musicians, for example, who perform with orchestras or other performing groups, or even gig performances, as long as they are working the necessary amount and they have their program of study was related to music, that's an okay situation as well. It's more difficult to track. They're going to have to keep careful track of all the documentation related to all their gigs and how much time they spent in each of those gigs, but it's permissible. Contract work is also permissible. So for example, if you're paid via a 1099 tax-wise as opposed to a W-2, that's still permissible as under standard OPT. Self-employment as a business owner is okay. Employment through a workforce agency is even okay. Volunteers or unpaid interns, as long as it doesn't violate labor laws. That's just kind of a review of what we just discussed. STEM OPT, again, is different. It has to be paid employment for 20 hours for each employer. So number one, employment relationship. You have to be an employee. Number two, it has to be paid. Number three, it has to be at least 20 hours for each employer. So you can't do the situation where you work 5 hours here, 7 hours there, 7 hours there. You can have two employers, 20 hours each, but it has to be at least that 20 hours. No volunteering counts toward this requirement. So you can't, if you're on STEM OPT and all of a sudden your hours have been reduced under those 20 hours, you can't go and volunteer to make up that additional time. On that point, what if I now work for less than 20 hours? So your employer, because of the current situation, has reduced your hours under 20 hours, still working, or let's say it's a volunteer, it doesn't have to be your employer, but your work period, what you're doing for your OPT is now reduced less than 20 hours. Ordinarily, in order to not accrue on unemployment days, you have to be working for at least 20 hours a week. However, as of May 12th, 2 days ago, SCVP released a new FAQ that indicates an answer to a question that's quite confusing. It raises more questions than it answers, but it's potentially helpful. So we'll discuss it. It says, must students cease engaging in OPT if they are now working fewer than 20 hours a week due to the economic impacts of COVID-19? The answer from the government was, for the duration of the COVID-19 emergency, SCVP considers students who are working in their OPT opportunities fewer than 20 hours a week as engaged in OPT. That's the entire response that we received from the federal government. No additional detail. This leaves a lot of questions. And again, this is only, to our understanding right now, for standard OPT. This does not appear to apply to the additional requirements for STEM OPT. Number one, what does COVID-19 emergency mean? It's likely that that is tied to the national emergency declaration made by President Trump, announced March 11th, effective March 1st, and still in effect now. All of these other policies that have been released at this point have been tied to that national emergency declaration. So that is our understanding that, and presumably it could also be retroactive back to March 1st. So from the period that the national emergency declaration was active, if you have been in a situation where you've had less than 20 hours of work on your standard OPT, then from March 1st forward, if you have been performing any work still, you may be okay from an unemployment days perspective. Second, what does working mean? In normal English usage, working means most often you're being paid. Right? Volunteering is one thing, working is a separate thing. However, for immigration purposes, working has maybe a little bit more broad meaning. It doesn't necessarily mean that it has to be a paid activity under the regulations and the law. It likely just means any permissible activities. So that list of permissible activities that we talked about counts as work. Volunteering counts as work for these purposes for OPT. And then finally, the most befuddling question is there a limit on how few hours you can be working and still be okay under this new policy? It's entirely unclear. If you're in a situation where your hours have been reduced to 15 hours and you have clear documentation of those 15 hours of work each week, I think you're very much, you're in a pretty good position to rely on this new policy for as long as the national emergency declaration lasts. If you're in a situation, in contrast, where you've got maybe 5 hours or less, maybe 2 hours, or you're a gig musician where you're working 40 hours one week and 0 hours the next week, that gets more complicated. And it's the end point here is, can I rely on this for purposes of calculating my days of unemployment? And I think that it gets trickier the closer and closer you get to 0 hours, for example. One question that was asked specifically was, is 0 hours okay so long as I'm actively seeking for work? I think that's a situation where you're probably not okay because you're not performing work that's related to your OPT opportunity. If you're performing any work during a weekly period, I think that likely you can rely on this guidance. The more work you're performing, the better, and the clearer the documentation you have, the better. If it's ultimately questioned, we'll talk about that further when it could be questioned. But under the very vague and limited language of this answer, this policy, as long as you're performing any work on your regular OPT that's related to your area of employment, your area of study, your program of study, you have a reasonable legal argument to make if you're ever questioned in the future for the period for as long as the national emergency declaration lasts, from March 1st to whenever it ends. Okay? Related question. What if I've been furloughed, but I'm still employed? So there's a difference in US employment between a layoff and a furlough. A layoff means that you've been terminated from employment. You're no longer an employee of the company. There's no ongoing relationship that you have with the company. A furlough, in contrast, retains the employment relationship, but generally speaking means that you're not performing any active work and you're not being paid for work. Sometimes you stay on benefits. Most often you do stay on benefits. Sometimes you perform a reduced schedule. Maybe it's 20 hours one week a month or something like that, as an example. This gets more complicated, particularly given the new FAQ from SEVP. So laid off, clearly your unemployment clock is counting, unless you're engaging in some, at that point, find a volunteer opportunity, find whatever you can as quickly as possible that's related to your program of study so that you can avoid accruing those days of unemployment, particularly on regular OPT. STEM OPT, you've got to find employment that will get you above 20 hours. Is the way I read the requirement. So if you've been furloughed, the most conservative approach, just for your purposes, it may be wise to track how many days you are furloughed, and to calculate that as days of unemployment. That said, standard OPT allows for unpaid opportunities. You normally have to have 20 hours of work a week to qualify, but with the updated guidance that we discussed, there's a valid legal argument to make that little or even no work is necessary to avoid accruing unemployment days. So if you still have an employment relationship with that employer, you've been furloughed, particularly based on this new FAQ that says that you can work less than 20 hours and still be considered to be working for OPT purposes, you may have an argument to make. I think if you're performing no work at all, that argument is more tenuous. That may not be accepted ultimately, but it's still possible, certainly. So again, the best practice here is not to rely on this new policy if you can avoid it. If you need to avoid it, document it carefully, document exactly what you're doing and when, and you should keep track of your days of unemployment for your own purposes. For STEM OPT, paid employment is required. So even a furlough likely counts as unemployment, in my opinion, since not being paid and you're not performing work. Okay. What if I'm outside the US? I decided early on in this COVID-19 craziness to return to my home country. I'm in my OPT period, but I'm still performing work for my OPT employer. Now that can get complicated from an employment law perspective. That's something your employer will deal with. That's not what we're discussing here. From an immigration perspective, ordinarily what you're doing outside the US has no impact on your US immigration status. But for an F1 student, that can matter a lot because of those days of unemployment. So normally time spent outside the United States during a approved period of post-completion OPT counts as unemployment, unless you are either employed during a period of leave authorized by an employer, or you're traveling as part of your employment. So usually traveling as part of your employment, that would be considered maybe more short-term travel. But that's pretty vague. Argument could be made there. Now, part of the guidance released by the government indicates that time spent outside the US and working outside the US is permissible. You can work outside the US and it won't count towards your period of unemployment from a US immigration perspective. Still be in lawful F1 status, you're not accruing days of unemployment. It does still count towards your 1 year of OPT, so you can't just leave the US for 3 months and then come back in and expect to get 3 more months of OPT. That's not the way it works. Any time that you spend working is still counted towards that. OPT period. All right, I've touched on this pretty thoroughly as we've gone along, but what advice do you have if my employment situation on OPT has been interrupted by COVID-19? First and foremost, document, document, document. The government doesn't believe anything unless there's a piece of paper associated with it. You have to document any and all work and volunteering related to your area of study. Papering the work you performed is critical to doing all you can to secure your stay in the US. So if you're performing volunteer work, you need a letter explaining how long you've been performing volunteer work and how many hours you're doing that each week. If you've been doing an unpaid internship, you need to make sure that you're getting documentation on a regular basis. I wouldn't rely on an employer providing it to you after the fact or at the end of your period of work. Talk with your employer and indicate that I need some kind of documentation on a regular basis, every other week or something, whether it's a pay statement that shows no pay or just a brief letter saying for the last 2 weeks during this period, they performed this work. Do everything that you can to document the work that you are performing. If you're below 20 hours a week, best practice is to seek volunteer opportunities if you're on standard OPT in the meantime to avoid relying on the unclear policy guidance. You don't want to rely on that guidance if you can avoid it. But it is there if you need to use it. And particularly for standard OPT. STEM OPT, to be frank, the requirements really haven't changed all that much, in my view, as a result of COVID-19. If you're not able to do so and you're applying for an additional benefit, so if essentially USCIS asks you for documentation of your maintenance of status during your F1 period at any time in the future, seek the advice and assistance of an attorney. If that's someone through your employer, great. If they do not have attorney representatives and you're not sure that they understand the situation, seek out an attorney and see if you can connect them with you and with your employer. Okay, summary, and then Christine and those folks answering questions. If you want to raise any of those questions before we go on to H-1B, this might be a good opportunity. What's the impact of too much unemployment? We spent all this time talking about how to potentially avoid the 90 days for standard OPT or 150 days for STEM OPT in the aggregate. What does this mean? Why does it matter? The primary impact is future looking. So in a future change of status application, an H-1B, for example, you've got an employer that's pursuing an H-1B for you. USCIS wants to see proof of maintenance of status. And there's been an increasing trend where USCIS has asked for specific documentation extending back through your entire period of F1 employment. So all your entire OPT period, sometimes even all the way through if you engaged in F1 CPT during your initial, during your studies, they'll also want documentation of that, but particularly OPT. If they find that you did not maintain your status, you got too many days of unemployment, then the change of status piece of that application will likely be denied. Doesn't mean that you're not going to be able to get the H-1B eventually. Just means you might have to depart the US, apply for a visa stamp at a consulate, and re-enter in order to transition to that H-1B status. At the adjustment of status stage, USCIS, again, looks back through your entire US immigration history. Doesn't matter when you last entered, they are looking through the entire history now. And they can ask for proof of employment authorization and or employment during your F1 time. If they find that you have violated your status for more than 180 days, there's a provision for employment-based green card applicants where you're kind of forgiven 180 days of unauthorized status or work or whatever it is. But if you go over that 180 days, you could be denied the green card and would have to seek a waiver in order to obtain the green card, which can be difficult to come by. Consular applications. If you exceed the unemployment days, you're arguably violating status. So even if none of these other things come up or are issues for you, you may have to answer yes to the question that asks whether you've ever violated your status on the DS-160 visa application. Again, not necessarily a killer to your opportunity to be in the US or return to the US, but it can complicate things. Finally, the F1 unlawful presence memo. This is currently suspended as a result of litigation. So I don't want you to worry too much about this at this point, but just to throw this out there, if the litigation continues and this memo is reinstated, then you could begin to accrue unlawful presence from the effective date. If you have at any time in the past violated your status, then once that memo becomes effective, if it ever becomes effective, you would begin to accrue unlawful presence and would have to try and do something to resolve that issue. Significant consequences there. If you have over 180 days of unlawful presence, you're subject to a 3-year entry bar. If you have over a year of unlawful presence, you're subject to a 10-year entry bar to the US. So again, the stakes are high here. The important thing is document what you can, find opportunities, particularly on standard OPT. If you're under that 20 hours, try and get above that 20 hours to avoid accruing those days of unemployment.
Stephen?
Yes.
There was a good question in the chat about whether students are eligible to apply for unemployment benefits while being furloughed.
That is an excellent question. So this is a state-by-state question, and I cannot advise specifically outside the state of Colorado. However, generally speaking, for F1 OPT, it's likely that you could apply for unemployment benefits. Most states require that you're available to perform other work, which in many statuses is not true. You're not available. For F1 OPT specifically, because you've got an EAD, it still has to be related to your program of study, so it's not a blanket EAD that you can perform any work. You can't go work at McDonald's as a mechanical engineer unless you were actually doing mechanical engineering work for McDonald's. But you can likely apply for unemployment benefits. Now, importantly, the next question after that is, okay, let's say I'm able to get unemployment, or let's say I received a stimulus check for COVID-19. Are either of those things considered public charge benefits? There's a rule that you have to report any means tested benefits to the government now in any application essentially that you're submitting to the government. And that can have an impact on your eligibility if they find that you are likely to become a public charge, is what it's called, meaning that they think you're going to rely on public benefits to subsist in the US. Generally speaking, the unemployment benefits and the COVID-19 assistance that was provided are not considered means tested benefits, don't have to be reported to the federal government. And that's because for most unemployment, you have to have accrued a certain number of quarters. And it's not based on your financial status. It's based on the work that you've performed and whether you are actively seeking work. So not a concern from a public charge perspective, generally speaking.
Thank you.
Other questions before we move on to H-1Bs? Okay. Let's keep going. H-1B. So you'll recognize if you've seen these presentations before, some of this content. We're going to talk a little bit more specifically about what the current situation is here, but the very basics. So an H-1B, the basic requirement of an H-1B is that the position is in a specialty occupation. What that means is that the position requires a bachelor's or higher degree in a specific field. So classic example, mechanical engineering position requires a degree in mechanical engineering. That's a very strong, clear H-1B petition. something that's not as clear, a sales position with a company that just requires a bachelor's degree, doesn't list any specific field. That's going to be a more difficult H-1B argument, because the government will say, great, it requires a bachelor's degree, but it's not in a specific field. Sales position can require a degree in philosophy or English or business. It's not a specific field for purposes of H-1B. Second, you have to possess that education or equivalent. So your degree has to be considered a match, essentially, for what's required for the position. So if you have a computer science degree and you're applying for a software developer position that requires a degree in computer science, information technology, or related, that's a pretty solid H-1B application, and you qualify because of your degree in computer science. If your degree is in philosophy instead, but you have a computer science background, you may not qualify for that H-1B, even though in the real world you are desirable and qualified from the employer's perspective, unless you have sufficient work experience to equate to a degree, which is substantial. And then finally, just so you're aware, employers are required to pay the required wage, which is the higher of the prevailing wage or actual wage. Actual wage means they have to pay you the same as they're paying similarly situated U.S. citizen or permanent resident workers. Prevailing wage is set by the government. Right now with furloughs and layoffs and reductions in salary, this gets a lot more complicated for H-1B folks. Generally speaking, companies can't do a lot to reduce salaries for H-1B folks because they have to pay them these wages. So it gets very complicated very quickly for H-1B workers and for companies trying to make decisions for those sponsored on H-1Bs. The primary limitation on the H-1B is the cap. There's a limit each fiscal year on the number of H-1B visas that are available. 65,000 generally available. Reduce that allocation for some taken by Chile and Singapore based on treaties for H-1B1 visas. And then there's a separate 20,000 for those with U.S. master's degree or higher. Now this says completed prior to April 1st. That's a little bit dated. You can complete it prior to submission of the H-1B petition. We'll talk more about what that timing looks like now. To give you an idea of what the odds look like, first of all, the government's fiscal year runs from October 1st to September 30th, which is why the window for filing an actual H-1B petition opens in April. We'll talk more about the difference between filing a petition and filing a registration. Here's an idea of some numbers. So this year was the first year where they used an electronic registration system. It was anticipated that there would be more applicants or registrants because of slightly lower barriers to entry, less work and fewer fees required to be able to be put in the lottery. And that came to pass. There are 275,000 registrants this year, the highest number that I think we've seen for H-1B. Back in 2016, we were at 236, and then you can see the other numbers here over the last years. Generally speaking, it's assumed that a lottery will always occur. This year, your odds were around 35% or so without a U.S. master's degree, closer to 45 or 47% with a U.S. master's degree. So again, as I said, this year was the first year that they implemented this new pre-registration system. Previously, you had to prepare the entire H-1B application. You would submit it in the first week of April, and then you'd hear over the course of 2 months or so back on whether your case was selected in the lottery, and if it wasn't, then they'd send back the entire application without even looking at it. Now, there's a simple registration system, requires very little upfront information, some information from the individual's passport, the company's federal employer identification number, and some details about the company contact, but it's pretty minimal. Registration fee is only $10, and it allows for the running of the H-1B lottery with minimal upfront information. This year, the registration period was open from March 1st to March 20th. You'd go in and create an account, complete the information, confirm that it's accurate, And then USCIS completed the lottery all by prior to March 31st, which is much different than it's been in the past. We got answers much more quickly. The lottery, importantly, as a result of this new registration system, has also been reversed, meaning essentially that it just increases the chances for those with U.S. master's degrees to obtain a registration. Instead of running the lottery first for those with U.S. masters and then lumping those in with the lottery for everyone else, they do it the other way around. So they run the lottery for everyone else first, meaning that some with U.S. masters will be selected, essentially shrinking the pool for then the second lottery for those with U.S. masters. So by reversing that lottery, they improved the opportunities for those with U.S. masters. If your case is selected, so you received a notification via email on March 30th that your case was selected, your registration was selected, you then have a 90-day window to submit the actual H-1B petition. So we're actively working on completing and filing those petitions right now. In most cases, it doesn't matter when you submit during that 90-day window. There is one really important exception that we're going to talk about called cap gap, that the timing of filing the petition matters a lot. But so long as you file within that 90-day window, your application will be considered. If you are approved, you could still be denied at this stage, but if you're approved that you qualify for the H-1B, then you will automatically transition to H-1B status as of October 1st, assuming you applied for a change of status. One of the key differences here that is a positive development as well is that USCIS has indicated that any registrations that don't have petitions submitted for them. So we've got 85 registrations that have been notified. They have until June 30th to submit the petition. If any of those don't submit the petition before that deadline, then at that point, USCIS will rescind that registration for that individual and will then provide the registration selection to an additional individual that had previously registered. So what we're anticipating is after June 30th, assuming that there are some companies that decide not to proceed with an H-1B filing, which is likely the case for at least some, after June 30th, we anticipate receiving some notifications of cases that have been selected. Now, they have no indication, we have no indication of how USCIS is going to prioritize those. Presumably, they assign them some kind of priority number when they ran the lottery, but we don't have any insight into that. But it's possible, theoretically, that someone could be notified of a selection as far out as September 30th of 2021, because that's the end of the government fiscal year for this H-1B cycle. So not something to rely on necessarily, but the prevailing thought was before that there were a number of H-1B registrations that weren't used each year. And now the thought is that this will help use more of those registrations and slightly increases the opportunity for people to be selected for an H-1B. If you are selected afterwards, you would then have a 90-day window to submit the actual H-1B petition. So if you're selected on July 4th, you'd have up through, say October 3rd to submit the H-1B petition as a result of that registration selection. Again, you should have a copy of the presentation. Here are a few links that are government specific. There are also some private websites that pull the data from these websites. If you find those easier to search, great. The point of this information is that it shows what companies have sponsored H-1B employees. It also shows green card information for perm labor certifications. But for H-1B purposes, this may be helpful to you in looking to understand, well, has my company ever sponsored before? Or maybe I'll look for employment with a company that sponsors a lot of H-1B employees. You can use that data. Now, to be clear, many employers are willing to go through the process for an H-1B employee. and they may not have ever sponsored an H-1B before. So caveat, don't necessarily limit your search based only on this data, but hopefully it can be helpful to you in identifying or prioritizing how you want to pursue applications. Okay, we've been talking about the lottery. We're going to take a brief break for a minute, and then we'll come back to the lottery and talk about something called cap gap.
Stephen?
Yes, please.
Is there a moment for a couple questions?
Sure.
Okay. So one question that came up was, if someone's number gets picked in the lottery for H-1B, and then they decide to change employers, or that position ends and they get a new employer, are they able to still use that number to be able to, for their new employer to file an H-1B on their behalf?
That's a good question. The answer to that is no. The registration is employer specific. So, you now as an H-1B holder, let's say, for example, you're able to continue that with your employment up through October 1st. Your H-1B petition is approved and goes into effect October 1st. If you're able to get into H-1B status with the current employer, you can then transition to another employer relatively easily by filing a new H-1B. But that wouldn't happen until after October 1st. But to answer your question, Amy, no, the registration is employer specific. So if you leave to go to another employer, or your current employer decides not to pursue the H-1B, then that registration doesn't do you any good.
Okay, thank you.
Other questions? So just the one for now? Okay. So just quickly, H-1B cap exemption. This is not a primary focus, but I just want to make sure you're all aware. Certain institutions are not subject to the lottery system. There's no limitation on the number of H-1Bs available to them. They can petition at any time. There's not this kind of April-October cycle. First and foremost, colleges and universities. This is not just for professor-type positions, although it depends on the university's willingness to sponsor. Second, nonprofit entities affiliated with a college or university. This is most typical in the context of university teaching hospitals. So Children's Hospital, for example, based on its affiliation with CU, would likely be considered cap exempt. Nonprofit research organizations. So again, this is not just any nonprofit. This is nonprofit research organizations. Governmental research organizations. This includes local government, state government, city government, county, federal government. Excuse me, any level of government. And then on the right-hand column, some more limited examples. A for-profit employer who employs a worker at a cap-exempt worksite. Some employers, for example, have labs that they pay for on a university campus, and they have employees in those labs. That would still be considered under certain circumstances, so long as it's still benefiting the university, as a cap-exempt petition, even though the employer is for-profit, because the physical location of the worksite is on a university campus. That would be cap-exempt. You can also engage in concurrent cap-exempt and cap-subject employment. So let's say you have up to 20 hours of employment with a for-profit company, and you have at least 20 hours of employment with a cap-exempt employer. That 20 hours of for-profit work would still be considered cap-exempt. So you could have those two H-1Bs going at the same time and not have to go through the lottery. Then finally, there's a group of exemptions for physicians who are subject to home residency requirements as a result of their J-1 visa. Those physicians are considered cap-exempt as individuals. So it's kind of a unique situation where they carry that cap exemption with them regardless of the employer they go to. But there are substantial limitations on those folks. They have to serve a period of service for 3 years in an underserved medical area. But those are kind of the examples of exemptions Now we're going to pivot back after we talk about some pros and cons to cap-gap specifically, more of the interaction with F1 OPT and H1B. Number one, advantages of H1B. You have portability. You can change employers relatively easily. You can begin working for that new employer as soon as the H1B petition is received by USCIS. Doesn't even have to be approved once you're in H1B status. With an improved I-140, which is the second step of the green card process, your spouse can get work authorization. Because it's dual intent, it's easier to transition to a green card, though not required to transition to a green card. And you can get additional extensions beyond the 6-year maximum if you're from a backlogged country, India or China, once you've completed certain steps of the green card process. Disadvantages, it's tied to a specific employer, no self-sponsorship, lottery, you have to be working in order to maintain your status, and generally speaking, there's a 6-year limitation. Cap gap. F1 OPT and H1B cap. So based on the new H1B cap timeline, we register during March, we're notified by the end of March, filing window opens April 1st for 90 days to file the actual petition. In order to qualify for cap gap, and we'll talk more about what that is, you have to file the petition, not just the registration, the actual H-1B petition prior to the expiration of your OPT. So if you have an OPT expiration that's in April, this is going to be very, very important. If your OPT expiration is in July and you're selected, you're pretty much guaranteed that it's going to be filed. If it's in May or June, you just want to make sure that it's filed prior to the expiration, that H-1B petition is filed prior to the expiration of your OPT. So cap gap, what is cap gap? If your OPT EAD expires after April 1st, let's use next year as an example. You've got an expiration of April 15th, 2021 on your OPT. You can get work authorization extended automatically up to September 30th, 2021, if your registration is selected and you file an H-1B petition prior to April 15th. This extension happens automatically once the H-1B petition is filed, generally speaking. However, you should communicate with your ISSS office just to make sure that it's showing up in their records, to notify them, provide them a receipt notice so that they can provide you with a new I-20 if you'd like for your records. Importantly, if your EAD expires after February 1st but before April 1st, so you're not in a situation where you're going to be able to get cap gap as far as work authorization. But in a situation like we're in right now, if you need to remain in the US, you can remain in the US if your H-1B petition is filed before the end of your 60-day grace period. So if your OPT expired March 1st, you have a 60-day grace period up through basically the end of April. If you file an H-1B petition before the end of that 60 days, you can remain in the US while that H-1B is pending. Can't work after your EAD expires, but you can remain in the US. I want to give an example here. This is a common question. I've been selected in the registration. My standard OPT expires June 15th, 2020. My employer has submitted my H-1B cap petition based on that registration. I've been issued a cap gap extension through September 30th, 2020. I'm eligible for a STEM extension of my OPT. Do I need to apply for it, and when? Generally speaking, your default should be apply for the STEM OPT extension. However, in this specific circumstance, you may not have to. So you've been granted a cap gap extension. You can wait until closer to September 30th to see if filing a STEM OPT renewal is necessary. If your H-1B is approved, and it's approved as a change of status effective October 1st, there's no need to file your STEM OPT renewal. If, however, your H-1B is still pending, say as of the beginning of September or even August, it's likely advisable to go ahead and submit that STEM OPT EAD renewal. That way, number one, you get an automatic extension of work authorization for 180 days past your expiration, just by filing a STEM OPT EAD renewal. The government has confirmed that filing a STEM OPT renewal during your cap gap period is allowed. So that's not a problem from that perspective. The key here is you don't want a gap in work authorization if you can avoid it. So if your H-1B continues to pend after September 30th and you haven't filed your STEM OPT renewal, your cap gap ends as of September 30th. You are no longer work authorized. You have to stop work as of October 1st. You can't resume work until your H-1B has been approved. Now, you can remain in the country during that period of time, but you cannot perform work after September 30th unless you've taken the step to submit your OPT renewal, your STEM OPT renewal. All right, that's H-1Bs. Just very briefly, here's the slide. There's a whole bunch of different non-immigrant visa categories. I just include the alphabet soup to let you know that there may be other options. They are fairly limited. H-1B is the primary one, but you know, it may be worth looking at whether other options may be available to you. Amy or others, are there questions before we move on to a quick summary of what we're seeing from a legislation and executive order perspective?
Not too many. There was one question about seeking a cap exempt employer if someone doesn't get picked in the lottery, in the H-1B lottery.
Yeah, so again, cap exempt employers, as long as you're able to land a job, they are a great option, and they can pursue an H-1B for you at any time. So if you're coming up on your OPT expiration in the coming months and you have been selected in the lottery, if you're able to find a cap exempt employer, then you should pursue that so that they can try and get that in place before the end of your OPT.
Hi, Stephen. This is Christine. I have one more question.
Okay.
Someone said, due to this COVID situation, if getting a license and diploma gets delayed for recent graduates who've already filed an H-1B petition, what happens to the application if those documents can't be submitted before the 90-day window period to submit the petition, the license and diploma?
Yeah, that's a really good question. So generally speaking, that's not too concerning. As long as you're able to obtain transcripts, in that situation, you'd probably want to get some official transcripts. If for whatever reason that's not possible, then even unofficial transcripts, as long as those are submitted along with the application, USCIS isn't going to deny the case in that situation, almost certainly. Now, they may issue a request for evidence and ask for proof of completion of the degree, at which point you'd want to have the degree certificate and be able to provide it. But it's much more important to just go ahead and submit prior to the end of that 90-day window than to wait or not submit as a result of not having a degree certificate, so long as you have those transcripts.
Great, thank you.
All right, legislation and executive orders. Again, you've seen this chart if you've joined one of my presentations previously. Just as a quick reminder, federal government changes can happen more quickly or much slower. Executive orders can be done very quickly and unilaterally. However, they do go through now, in particular because of successful legal challenges, court challenges, they do go through quite a bit of vetting before they are released from the Department of Justice, Department of State, a variety of agencies. So it's not as if the president, generally speaking, just writes something up and turns it into an executive order. It does take some time. There is some process involved. Policy guidance, we've discussed, that can be implemented very quickly without a formal process. We've seen that a lot with COVID-19. Regulation changes have to follow a formal rulemaking process. For example, this administration has wanted to get rid of the H-4 employment authorization document program. In order to do that, they have to promulgate regulations, and they haven't been able to do that during the whole period of the administration, over 3 years now. So legislation requires Congress to act and requires Congress to agree together on something, which is fairly rare in our political system these days. There are several pieces of legislation that we'll talk about, some with greater chances of success, some with less. Very quickly, COVID-19 quick take. A summary of current situation. So U.S. consulates are closed for visas almost across the board. On exceptional basis, they are allowing for emergency appointments, but that's very limited. India is closed to all inbound, outbound travel. Mexico and Canada are limited for visitor travel, pleasure travel, but the border is still open with the U.S. for business travel. Travel ban from Europe to the US appears to still be in effect, but it hasn't been formally extended. We've had issues with some clients who have traveled to Europe and have been unable to enter the US as a result of the COVID-19 specific travel ban. Again, we've talked about remote work. It's okay for F1 OPT, remote study. Premium processing has been suspended, as well as the signature requirement for specific types of applications to ease the ability to file. I-9 verification can be done remotely if your workforce is remote, and USCIS field offices and biometric centers are closed at least through June 4th. In some cases, we're seeing USCIS reuse or excuse the biometrics requirement altogether and continue to process cases even if they're not able to capture those biometrics. It's not across the board, but we have seen those cases. Executive orders in effect. So this was the big attention grabber several weeks ago. In the end, it doesn't really impact probably anyone on this webinar, hopefully with very much negative impact. So the president signed an executive order instituting an immigrant visa ban. It was effective April 22nd for an initial 60-day period, but with an option to extend if necessary. This only applies to individuals applying from outside the US through consular processing, so at a US consulate for a green card. As of right now, almost all the consulates are closed anyway, so the practical impact of this is pretty limited, at least as of now. Again, it doesn't apply to non-immigrant visas. It doesn't apply to individuals in the US applying for extensions, anything like that. This is limited solely to individuals applying for green cards at US consulates, and there are exemptions made for EB5 category, spouses of US citizens, and healthcare and COVID-19 research are exempted from this ban. Now, there's been a lot of discussion about additional potential executive orders. In that executive order that was released, there was some ominous language at the end that indicated that additional provisions will be forthcoming. And so there's been a lot of discussion over the last almost month now about what that could look like, what that could mean. Again, executive orders go through an extensive legal review process. Based on our governmental contacts, they've indicated that any additional provisions or executive orders are in very early stages of that review process. So it could be a month or more, depending on if those really move forward. For any additional limitations, if they end up even doing anything. Now, there's also a letter from 4 senators. We've heard from these senators before. They are fairly anti-immigration. They urged a suspension of OPT and new H-1Bs for 60 days. This is not something that has been specifically indicated that the White House is interested in pursuing. That said, it is in discussion. We don't know exactly what that would mean or what that would look like. Other discussions include some additional attestations for H-1B petitions, which could include attestations that you haven't displaced a U.S. worker or something like that. Unclear if and when any executive order will be released. Very unclear what it will look like when and if it is released. So be careful not to put too much stock in what you're hearing from the news media. It's good to be aware, but until we have something released, there's not really necessarily a whole lot that can be done, except perhaps trying to move forward with applications sooner rather than later, if possible. As far as discussed legislation, the HEROES Act has been introduced in the House. Because it is a bill from the House and that's Democratic controlled, it's unlikely to really go much of anywhere because once it goes to the Senate, which is Republican controlled, it will likely be struck down. It won't really move forward at all. This bill does contain substantial provisions related to COVID-19, relaxing requirements for expiring status, maintenance of status, etc. Has additional special provisions for workers in areas related to COVID-19, particularly healthcare. There's a separate act that's been introduced in the Senate that is viewed to have perhaps an increased likelihood of success. This is pretty limited in scope. It provides for additional green cards for physicians and nurses, particularly benefiting those from backlogged countries. So 15,000 additional green cards for physicians, 25,000 additional green cards for nurses to try and increase the healthcare workforce in the US in the short term. Parting thoughts. Be creative in finding opportunities for qualifying work on standard OPT. Look for volunteer opportunities related to your area of study if you're in a situation where you're under that 20-hour limit. Develop relationships with employers. On your OPT, your H-1B, if you're volunteering, try and understand opportunities to pursue additional employment so you can pursue STEM OPT or an H-1B. Plan for your future by avoiding violations of status if possible. So keep careful track of those days of unemployment. Track very carefully the work that you are performing so that if asked in the future, you can provide documentation that even if it's under the 20 hours, as a result of the new policy, you're still maintaining that status and not accruing on unemployment days. And finally, consult with an expert if you need assistance. As a result of my history with CU Denver and working with other institutions of higher education, I am open to students contacting me directly. I'll provide my contact information on the next slide here. You can reach out. The best way to reach out to me is via email. Give me a brief explanation of your question and situation. If we need to set up a call, we can do that. I'll do an initial consultation for free for students. If we can resolve it just via email, we'll do that as well. But I want to make sure that you feel like you have the resources that you need in this difficult time to understand your situation and understand if there's anything that you can do to improve or resolve your situation if you're running into issues. So that's the extent of what I wanted to talk about. Here's my contact information. Again, it should be in the presentation provided to you by Christine as well. This is being recorded, so you can review the recording in addition. But I'm happy to stay on for the next little while and discuss any further questions that have come in through the chat function, Amy and Christine.
Stephen, there is a question here. Can students apply for an EB-1 or a green card petition while on F1 OPT?
Yeah, that's an excellent question. So there are several steps to the green card process. 3 steps in some circumstances, 2 steps in other circumstances. For the EB-1, extraordinary ability, is what I assume the student is referring to. That is something that you can pursue with self-sponsorship. You don't have to have an employer sponsoring you. The bar is pretty high as far as qualifying for that type of immigrant petition. But that is the first step in the green card process, called an I-140 immigrant petition. You can submit that I-140 immigrant petition without issue. It's not going to affect your F1 status. It's not going to be an issue in future applications or anything like that, that first step is completely permissible. Where it gets more complicated is when and if you're able to take the second step, the adjustment of status, or Form I-485. At that point, then you are indicating that you are pursuing a green card, which for all intents and purposes effectively violates your F1 status because you are supposed to intend to return home. Now, doesn't mean you can't submit that adjustment of status. It just gets more complicated, and you'll want to seek expert advice on that, what that looks like, how that's possible, because you want to make sure that you take all steps necessary to not abandon your green card by leaving the US while that is pending or something like that. But it gets a little bit more complicated. Still possible, even on F1 status, but just more complicated. So yes, you can pursue an I-140 immigrant petition without having any impact on your F1 status. It's just at the second step of the process, you'll want to be more careful.
And kind of as a follow-up to that, Stephen, can students apply for OPT while also filing, the I-140 or a green
Yes.
card application?
So, well, yes. So the I-140 has no impact on any other applications. It's very clear by policy that an I-140 petition by itself does not violate non-immigrant intent. Filing the green card, again, gets more complicated. Any subsequent applications after you filed the green card application, the I-485 adjustment of status, can get much more complicated. It's possible, now generally speaking, I haven't seen this, it's possible, for example, that if you apply for a green card and then you subsequently apply for OPT or even apply for a STEM extension, the USCIS could come back and say, we see that you have a pending green card. You're not eligible for this F1 benefit because you're not maintaining your F1 status. Now, again, that is something that we haven't seen a lot from a practical perspective. We've seen individuals who have been able to file an adjustment of status and then subsequently renew their STEM OPT, for example, without issue. But it is a possible area of issues. And again, a reason why before you pursue that I-485 adjustment of status, you want to get an attorney to help you out.
Thank you.
Are there any other questions that I can help that are more broad? I see that there are a few people reaching out to me privately asking about private consultations. The best way to go forward with that is to go ahead and send me an email and a brief description of your questions. So please go ahead and email me. Here's my email address right here, and I will respond to you and we'll figure out how we can best assist you.
We just got a question here that says, what about working in the US with TN visa?
So as of right now, if you are a Canadian citizen or a Mexican citizen, those are the only two countries that qualify for TN status. And it's not just a permanent resident, it's a citizen of either of those two countries with a passport from those two countries. You can still apply for a TN. Now in Mexico, that gets more complicated because the consulates are closed. In Canada, if you're a Canadian citizen, you're visa exempt, so you don't have to appear at a consulate. And the border is currently open for TN applications. So you can fly to Canada. You may be subject to a quarantine in Canada, but once you fill that quarantine period, you can then apply for a TN at the point of entry.
There's another question, Stephen, about self-employment while on F1 OPT. What happens after the OPT expires?
So if you're, now again, self-employment is only for the initial period of OPT. If you are in self-employment, you're self-employed, you have your own business, your OPT expires, your time is up. At that point, then you cannot continue working for that company, at least in the US, and receiving pay and being actively involved in the operation of that company. If you depart the US, you can continue, developing that company and pursuing that. If you're able to find additional forms of employment, you need to essentially find another option. You have 60 days to find another option after the expiration of your OPT, based on the grace period that you have. But you're unlikely to find an easy option for self-employment to transition into. H-1B, you can't sponsor for yourself. You could create a situation where those who own and run the company are someone other than you, and then that company pursues an H-1B on your behalf. If your ownership percentage is sufficiently low, you don't have a controlling interest in the company. But that's kind of one of the only situations where you may be able to continue to operate the company after that 1 year of initial OPT.
Thank you. I think there was just one more about obtaining an EAD for an H-1B spouse.
Yeah, so as of now, that program still exists. In order to do that, you have to have an approved I-140 immigrant petition of any kind. So that can be an EB-1, extraordinary ability, self-petitioned I-140. That could also be an EB-2, perm labor certification based I-140. Some require employer sponsorship, most require employer sponsorship, some don't. But you have to have that I-140 petition approved, which usually takes a year or more, depending on the process that's used.
Yeah, thank you.
Any other questions?
Looks like a lot of individual questions at this point, Stephen.
All right. Well, again, here's my contact information. Please feel free to reach out to me, and appreciate the opportunity to speak with you all. I hope that you're all doing well, staying safe and healthy.
Thank you, Stephen.
Thanks so much, Stephen.
Thank you all.
Okay, so to everyone, we're going to send this recording out to you if you were registered for this webinar. And feel free to email any one of us in ISSS if you don't receive the recording. Thanks.